All right, everybody. So we're going to cut out of that feed. I want to talk about the McIver case because before we cut out, there was an interesting back and forth there between the attorneys and the judge. And I want to talk about it now with my guest for this morning. Again, we're here with criminal defense attorney and former prosecutor Nicole DeBorde. Nicole, the issue was about the jury being able to go into the SUV with the gun. But the SUV wasn't put into evidence by the prosecution, and now the judge just put it into evidence. Have you heard of that happening before?
So it's very unusual, and the prosecutor was arguing to the judge that the judge has discretion to allow this non-evidence to go back in front of the jury, and the defense was saying absolutely not. The prosecution didn't offer this car into evidence, and the jurors shouldn't be able to get into it now because it's not in evidence. So the prosecution says, Judge, you can now let the car into evidence. Interestingly enough, it appears that the judge in this case has actually said, I'm not going to let it into evidence. However, I am going to let the jurors get into it. And obviously the defense is objecting to this. You know, secretly, I think sometimes as a defense attorney, you're actually hoping a judge does something strange like this, because what it can do is actually lead to error. If ultimately there is a conviction in the case.
Well, if you look on our Twitter feed or you just follow this case in general, many people have been critical of Judge McBurney, saying that he is very pro-prosecution and he flavors his ruling towards them. So I think that there might be grounds for an appeal. If in fact Mr. McIver is convicted, there might be some grounds there. It was funny, Bruce Harvey said, you are doing the work that the prosecution failed to do. It was their burden to put in the SUV. Now, why would the defense really not want the jurors playing around in there?
You know, what the defense doesn't want is for the jurors to go back and start conducting experiments. The defense wants the jurors to be able to look at the evidence that was presented in trial and make a decision based on that evidence and that evidence alone. And when you start letting the jurors have things that weren't admitted into evidence, and you start letting them get into vehicles that were never offered into evidence and conduct experiments, they're really considering evidence that's not evidence at all, that never came into trial, and can really affect their decision.
Also an issue about whether or not this is still jury deliberations. Jury deliberations are just with the jury. No one else can listen in, even a fly on the wall. I wish I was. I wish I could hear what they're saying. But the idea that the jury can go down to the SUV and attorneys, the judge, even the defendant is present while they're deliberating, is that still considered jury deliberations? And I know the judge is still mulling over whether Tex McIver can be present when they view the SUV with the gun, but is that still a jury deliberation? That's
a great question, and it's actually a very smart point that this defense attorney raised. The issue is that all deliberations are supposed to be conducted in secret, and the defense isn't supposed to hear it, the prosecution's not supposed to hear it, and the judge isn't supposed to hear it. But when you bring the jurors out of the jury room and you actually have them doing whatever they're doing in front of everybody, the deliberation now is out in their view, it's in public, and it's really not appropriate. The question is this deliberation? And it's not.
I'm not comfortable with this in the sense I've seen more rulings where the judge says to the jury, don't manipulate the weapon, don't act out the crime scene. You can view it, but don't do that. They're going to be they're going in the backseat of the car playing with the gun.
Right.
Say I'm making an assumption, but I have to believe that's what's going to happen. So I'm a little concerned about it. We'll have to see how it goes. But again, we are in verdict watch in the Tex McIver case, even though there's still more analysis being done by the jury. There's probably not going to get an answer by today. If anything, maybe later today, maybe tomorrow. But what we want to do is jump back into Florida. We're in the Brian Hyde case. We have a live feed. We'll come out. We'll talk about it a little bit. So let's go live. There's a witness back on the stand. All right, ladies and gentlemen, you're watching the Brian Hyde murder trial out of Florida. This is actually a quadruple, I should say that because it's a horrific quadruple murder, because you have 3 people that we know were killed, and then one of them was a pregnant young lady who had an unborn child and tragically was lost as a result of these horrific stab wounds. Now, again, the question is, why are the police Why did they circle around Brian Hyde? Let's talk a little bit more about it, again, with my guest for this morning, Nicole DeBorde. Why did they go after Hyde? What was it about Hyde that they said, you know what, he's our guy? Because the defense is really saying that the authorities didn't do a thorough investigation, that there was evidence that other people were in the home, that they immediately just narrowed their focus towards Mr. Hyde. What do you see that they have so far?
It sounds like they got a lead that there was a problem with Mr. Hyde. They ended up finding him. When they found him, they had evidence that he had blood still on his clothing, on his body. There's a lot of information that seemed to indicate that he was present in the home at the time of the killings because there's a lot of biological evidence here.
And he was picked up by police after driving one of the victim's Range Rovers.
Exactly.
So it's interesting when you see that, but how successful do you see when the defense attorneys make a ploy for saying, you know what, investigators, they missed a lot of information here, and they automatically assumed my client did it. I've seen that countless times on trials. Does that work?
It can work. I think it's an uphill battle in this particular case. I mean, there's just so much physical evidence, which is not always present. And when you have a case where it's just a bunch of circumstantial evidence, that defense tends to work a little bit better. When you have DNA and you have missing property that actually belonged to the complainants in the case, I think it's a completely different story. It's going to be a very, very steep uphill climb for these defense lawyers.
Well, we know that the medical examiner testified yesterday about the horrific wounds sustained by these three individuals. Again, we're talking about, I'll tell you who was a victim here. We know that Michael Kelly was 19 years old. He was viciously stabbed. His girlfriend, 17-year-old Starlet Pitts, was killed, as well as Starlet's mother, Dorla Pitts. She was 37. And again, as I said, Starlet had an unborn child named Ari Kelly, 25 weeks old, who died as a result of this attack. Now, there was also a 1-year-old baby that was found in the house, too. Unharmed. Don't worry, the baby's okay. But interesting, the defense honed in yesterday that the medical examiner didn't know if more than one weapon was used. You're the medical examiner and you don't know this? That's a big hit for the prosecution.
You know, there are always parts of a case that will have no answers, right? Questions that will have no answers. And in this case, the medical examiner's testimony was that these were terrible, brutal, violent stabbings. And it's much better for whoever the scientific expert is to get up on the stand and admit that they don't have answers to certain questions than to claim that they do when they're a little bit foggy on exactly what happened. So I think it was smart in this case for the medical examiner to say, I know exactly what happened in certain circumstances, but I can't identify the source of these other wounds.
And really, it's about reasonable doubt, isn't it, right? If you can just poke a little bit and say, wait a second, are you sure? Are you sure, to the best of the evidence shown, that this is the person that committed these crimes, or do you have a doubt, and is that doubt reasonable? That's really the question here. Now, what makes this case interesting is this is the second time that Hyde faces a jury. There was a mistrial back in November, and it was because of media attention that was drawn to the fact that Dorian Pitts, who again was related to these victims, he testified that Hyde came to live with the family after crossing into Texas illegally, and he spent time in a detention facility, and this became part of a larger conversation about immigration laws in this country, and they had to declare a mistrial. So when you have media bias, those questions are not going to be brought up now.
Right, no, I agree. And, you know, those are hot button issues. And I think that they cloud the real question, which is this person guilty of the murders that they're on trial for? And you start bringing in questions that are really politically hot button questions, and it distracts the jury. You want a jury who can answer the question, which is this person guilty of the crime that they're charged with? It's
not an even easy question for them to answer, let alone having other information brought in.
Exactly.
All right, here's what we're going to do. We're going to go back to the Hyde case. We're going to listen in. We are also carefully monitoring the Tex McIver courtroom. I'm looking at it right now. As soon as we have an update, we'll make sure to let you know. But let's go back into Hyde, and we'll talk a little bit about both cases when we come back. That wonderful white hair you see right there, that belongs to Tex McIver, the defendant. A face that we've seen for weeks. The jury has been, this has been 27 days of a case, and now they're in deliberation, so just add on to that. Again, I'm here with Nicole DeBorde. So you're watching this. We see the man right here. You're a criminal defense attorney. What goes into the minds of defendants as they're waiting for the verdict?
You know, it's terrifying. It's out of your control at this point. Your lawyers have done everything that they can possibly do. You've put your best case forward. All of the facts that can be gotten in front of the jury are there, and the jury has to make the decision. And you just wonder, what are they thinking? What are they doing? What are they talking about? What do they care about? How close are they to a verdict? A lot of things are going through his mind.
I mean, I'm thinking the same thing. I'm sure Don Samuel's thinking the same thing. I have a question for you. See, what's happening right now, ladies and gentlemen, as you tune in live, besides looking at a frustrated defense attorney right there, what you're seeing is the jury is being called back because they want to watch Tex McIver's police interrogation tape. Now, that's important, okay? What do you think they're looking for here, Nicole?
I think that they want to hear what he had to say right after the event. What did he tell police happened? How did he look on the video? Did he seem distraught? What kind of information did he give police, and is it consistent with what information the defense gave to the jurors in court?
Now, you and I haven't had a chance to really talk about this case. Do you think the prosecution has a strong case?
I think it's a little bit difficult for the prosecution in this case. It sounds to me like there's a lot of information to indicate that this was an accident. I think there were some inflammatory type circumstances surrounding the filing of this case, but I don't think that the physical evidence or even the testimony of the witnesses who were actually there points to Mr. McIver being guilty of the crimes he's been charged with.
You know, what's interesting is we saw the jury asked for copies of the jury instructions, which means to me, which it says to me, they're really following the law there. They want to know detail by detail how they should deliberate. So the reason I mention this is because there is a split in the law between murder, involuntary manslaughter, and an accident. Specific language right there, and I think specifically with involuntary manslaughter and accident, that is a really delicate line. So do you think that the jury, or maybe they might have said, you know what, this doesn't look like murder to me, but we are split right now between involuntary manslaughter and an accident?
I think it's very possible that that's a big concern for this jury. The reality is that they are going to have to consider whether or not what Tex was doing was so completely foolish or reckless that it rose beyond the level of a normal accident, or whether it was just a simple, terrible, tragic accident.
By taking the gun out, or let me rephrase, by having the gun handed to him, being put on his lap, and him having the gun on his lap, whether it was in a plastic bag or not, it wasn't a plastic bag, but is there any way that could be an accident, or did he create that situation? And I'm sorry, that's reckless conduct. He should be found guilty.
You know, it's not unlawful to carry a gun in this circumstance, and so just by having it in your lap, that doesn't rise to the level of being criminal. So the question is how did he handle it? Did he handle it in such a way that was so reckless that his conduct afterward is criminal? And that's the question that the jury has to answer.
All right, everybody, the jury's back in. Let's listen in to Judge McBurney speaking to them. Okay, ladies and gentlemen, as they work for getting that audio equipment set up for the video, this is, again, the jury wants to see this interrogation tape again. They want to hear what Mr. McIver was saying. This was only a few days after the shooting. And remember, whether or not he gave consistent or inconsistent statements is key here. So let's listen in live to the tape. All right, I know the audio on that is not great, so let's stand back. We'll listen to what, and many of you have seen this already. Again, I believe that's Stephen Maples, who was Tex McIver's attorney back in the day, right when, let's not forget, Mr. Maples is a key figure in this case. McIver called Maples at the hospital when they brought Diane McIver there after being shot. So the question became, Mr. McIver, and I'm going to ask my guest here, Nicole, again, if you call your attorney right after the shooting, does that make you look suspicious, or is that something anybody, if you're in a position where you just shot somebody, that's the first person you'd call?
Absolutely the first person that you'd call. It's obviously a very serious legal problem, and the first thing anyone should ever do in that circumstance is call for help and then call an attorney. You should not be making statements to law enforcement without the benefit of having an attorney present to advise you.
Okay, here's what we're going to do. Since the audio on that's pretty not great, we have a replay clip of when this was played first in the trial a few weeks ago. So we're going to play that for you right now, and it has subtitles. It's a little bit easier to understand, and then Nicole and I are going to talk a little bit more about it. Let's listen in. All right, everybody, again, that is the live feed in the Claude Tex McIver courtroom. The jury wanted to see this interrogation tape again. So let's talk a little bit more about the conclusion of this case with my guest for this morning, criminal defense attorney and former prosecutor Nicole DeBorde. Nicole, when you see juries asking to relook at information, to look at evidence again, and we talked about earlier the jury wants to go back into the SUV with the gun, and there was a whole debate about whether the SUV was put into evidence or not, and we'll talk about that. But when they want to look at evidence again, what does that tell you about their recollection about what they thought was important in the case? Is that a way to look at it?
Sure. It could be that there's someone on the jury who is having a dispute with another juror about what the statement was. What did he say? And maybe they're remembering it differently, so they want to go back and watch it again and make sure that they're in agreement as to what exactly was said on the tape.
Do you think that the one area of contention and one area where they might have confusion is about, and I think it's probably the most important, where was the gun placed? Was it on Mr. McIver's lap? We heard from Ross Gardner, who was a defense expert, said it's impossible for the gun to be upright. Do you think that really is the question there in terms of why they want to get in the SUV, to understand was the gun, how this could have happened? Because again, the defense has said, is Mr. McIver a diabolical mastermind that he is going to shoot and kill his wife by putting it on his lap and firing from the side, and maybe the bullet will go through both the seat and kill her? Because that's what the defense is saying.
Sure, and I think that the defense has to be concerned about that, because it's very difficult to recreate a circumstance that could have 1,000 different variables, which is why the jury isn't supposed to be conducting experiments in the first place. So it is probably one of the reasons the jurors do want to get into the vehicle, to see whether or not the testimony that they heard on the stand lines up with what they can see physically in the vehicle. And the risk is they may want to get in the vehicle and try to recreate this circumstance. Well,
we can't forget the fact, and as much as we say the defense has done a great job, this guy that you see right there, Tex McIver, he is the shooter. And that provides an interesting aspect to this case, no?
Absolutely.
That we know who did it.
Sure, absolutely. There's no question at all that Tex McIver is the person who shot the gun in this case. And big question that the jurors have to answer is whether or not this was an accident, or whether or not it was so reckless that it should be a crime.
Now, the jury can come back to any testimony, right, that they want to listen to. They can get a copy of the transcript, correct? So if they're like, what did that witness say? What I've noticed so far is they haven't asked any questions about this financial motive. So that financial motive was put forth by the prosecution since the beginning, trying to understand what happened to the will, the finances, his finances, her finances, their relationship. Yes, they want to look at some of her emails, but the fact that we haven't heard so much about, well, can we see the transcript of the financial expert again? Does that mean that they're not quite buying that theory? Or is it that they, you know what, we remember it, we know what the gist of it is?
It really could be either one. It could be that they just don't care about that particular information or have discounted it entirely, or it could be that they just have no dispute at all about what the testimony was in that regard. Jurors can't just ask for blanket, complete transcripts of a witness. What you have to do when you have a question about testimony in the courtroom is tell the judge, this is the particular part of the transcript that we want to hear about. This is the issue that's in dispute. And they haven't asked for it.
Nicole, I'm going to ask you one final question. When do you think we're going to get a verdict?
Good question. Maybe sometime tomorrow.
Okay, but not today. They still have more to do today.
Lots of information that they want to see again. So I think today may be a tall order.
Will it extend into next week?
It could. You never know.
It could. All right, everybody. This is Nicole DeBorde. Thank you so much for joining us here today. It was great having you on.
Super. Thanks so much for having me.
All right, everybody. So we see that there's a feed right now back in the Tex McIver courtroom. Let's listen in live.